All right, hello again. Welcome to Employment Law Show. John Scholes, Lior Samfiru, co-founding partner, Samfiru, Tumarkin LLP, the most positively reviewed employment law firm in the entire country. How about that? You want to reach out to Lior anytime during or after the show? Phone call works great, 1-855-821-5900, help@employmentlawyer.ca. And throughout the show, I know we're going to refer to pocketemploymentlawyer.ca. That is a free, anonymous website, all kinds of employment law information for you to learn. And wrapped up into that is the severance pay calculator, which has helped hundreds of thousands of people realize what the proper severance number is. That is now part of pocketemploymentlawyer.ca. On the show, Lior, things employees should never do before calling Lior first. That is coming up in just a bit, but we always start that and some phone calls from our long-running radio show, and we'll give you some details on that as well. But first, pal, we always start off with the week that was, a matter or two that's been going on with you.
Absolutely, and there's always a lot to choose from because there's always a lot of calls, questions, issues that I'm dealing with in the office, but that's good because it allows me to give some information, to try to help solve problems, and that's what we do on this show. We'll do that today, we'll do that on every show, answer questions, tell you about the things that you need to know. Maybe right now you're watching this on the weekend and that Friday wasn't a good day and you're going to go back to work Monday. You don't know what to do. You don't know what to say, how to respond to your employer. Maybe there's an ultimatum. We're going to address that and all those other things. Certainly if you've lost your job and you need to understand what to do, what you're owed, we cover that on every show. Those are such important things. You need to know your legal rights. The law is actually not that complicated and the law is very good. But none of that matters if you don't know what it is. That's why we are here, to tell you what you need to know, to educate you, to help you. And of course, if you hear something today and you want to follow up, you want to talk to me personally, you want to have that chat to get more information about your specific situation, not a problem. We'll give you that contact and information throughout the show so that we can connect. But now that we've gotten that out of the way, John, week there was, let me tell you about a situation that came across my desk just over the past few days. I spoke with a gentleman who had worked for the same company for about 8 years. He was happy there. He wasn't looking to leave, wasn't shopping his resume around, was content to do his thing. Except a little while ago, he was approached by another company that worked really hard to try to recruit him. And they worked with a headhunter, and eventually, after meeting with them several times, they promised him more money. He said, sure, I'll make the move, and he made the move. Started working at the new company. Fast forward 2 weeks later, employer says to him, well, wait a second, we realized we never asked you for your vaccine certificate. So just give us your vaccine certificate. We need to have that on file. Well, John, he wasn't vaccinated. And he told him, well, I'm not vaccinated. I'm not planning on being vaccinated. They write back immediately, or they call him back, and they say, well, because of that, this is not going to work. So we're not going to continue with you. We're going to be ending our relationship with you, and all the best to you. Now, he'd only worked there for 2 weeks. He called me, of course, and he wanted to know what to make of the situation. So let's be very clear here. First of all, that vaccination was not a term of his employment. They could have said right at the beginning when they hired him, to work here, you have to agree to be vaccinated. That wasn't the term. They imposed that, implemented that after he had already started working. So when they let him go, that is a termination without cause, meaning he's owed severance. But here's where it gets even more interesting. Because they recruited him from another job, we call that inducement. They induced him to leave another job. Now that they let him go, they have to pay him severance based on the time that he had with the previous company. So, John, even though he had only worked for this company for 2 weeks, because he had the previous 8 years with the previous company, he's now an 8-year employee and should be getting severance as an 8-year employee, right around 10 months of pay, 10 months severance. So he worked for 2 weeks. He's owed 10 months severance. So two very important lessons here. Number one, when it comes to vaccines, ultimately, as I've said before, there's very good reason people should be vaccinated. But that aside, if you're not vaccinated, unless there's a government mandate in place, if you are let go, you're going to be owed severance. We want to be very clear on that. And second, of course, if you are recruited from another job, only to then be let go, you will likely be owed enhanced severance that recognizes your time with the previous company. So more of a reason now to give us a call if you lost your job, because we really need to assess everything that you're owed.
And just to be clear, the severance is paid by the company that induced him and pulled him. This has nothing to do with his former employer, right?
Exactly. Yeah, so the company that let him go is the company that has to pay him. And even though they'll be shocked when they realize this guy worked for us for 2 weeks, 10 business days.
It's expensive.
And now we have to pay him after 10 business days, 10 months pay.
Wow.
That's how the law works. But again, he wouldn't have recognized or understood that if he hadn't called. Now he knows I'm going to get involved to get him that help that he needs. Same with you if you're in that situation.
Was this something that could have easily been avoided by this employer had they, at the outset, in an employment agreement, said to work here you need to be double vaxxed, so on and so forth?
John, obviously you and I have been doing the show for a while because you know exactly that is a game changer. Two things that employer could have done with an employment agreement. Number one, stipulated in that agreement that to work here you have to be vaccinated. Then if he's not, he agreed to be, then they can let him go, no compensation. The other thing they could have done is try to limit his future severance entitlements in that employment agreement so they don't get this 10-month bill after only 10 days of work. They didn't do either of those things. Because of that, now the law comes in and says, you have to pay this gentleman this amount. Now, you may not have been recruited from another job, but if you lost your job because of the vaccine or really for any other reason, yes, you're owed severance, and that severance almost always is going to be measured in months, not weeks.
If it was take it one step further, if it's part of an employment agreement to get the job initially, had to be vaccinated, okay, fine, he got hired. Somehow it slipped through the cracks. Someone in HR dropped the ball. He got hired, he's working there, then they realized he wasn't vaccinated. Is that cause to let him go?
If he had agreed to be vaccinated, then it is cause. If it was a term of his employment, he signed something that says you agree by walking in here on Monday for your first day of work that you've been vaccinated, and despite that he's not, that would be cause because it was a term of employment. On the other hand, if the employer says, we've decided moving forward, we want you to be vaccinated, there was no term of employment, in that situation, if the employee is let go, it's not cause. It's a without cause termination. And of course, when we're talking about without cause terminations, severance automatically has to come to mind.
Again, confusing at any time, 1-855-821-5900 to get a hold of Lior and his team. And I mentioned the radio show, right? Employmentlawyer.ca. That's the website you want to go to, the media tab. You'll find a station here in Ontario or BC, Alberta, somewhere across the country that carries our radio show, has been for about 10 years. You want to listen to that. You can even call in and ask some questions. We like to play calls back on the TV show here and talk about them. First call for this show today is coming up right now.
Been working full-time running a restaurant for the last 9 years. We shut down at the start of COVID. The week before we opened, I got hit with a medical issue that landed me in hospital. And I let the ownership know right away that I had side effects, but I had no idea how long it was going to be. So I kept in touch with them every month or two that the doctor was going to be putting me on a medical leave. I got clearance for in March to finally start working. Contacted them that I've got my ability back to work. However, I found a job posting on the company's website for my position about a month or so before that.
So obviously there's something wrong going on here, but you know, I would tell him for now, let's wait. And the reason for that is, yes, he may have seen his job posting there, but the time when you actually know if you have a job is when you're ready to come back to work. So if he's not ready to come back to work at this time, we don't deal with it. Once he's clear to return back to work, once his doctor says, yes, you're ready, he contacts his employer. If his employer takes him back, no problem. If his employer does not take him back, then he's owed severance and potentially maybe even human rights damages. If he was let go because he was on leave, or even if that's part of the consideration, that may be a human rights violation. But just because the company is looking to hire someone now, even though he believes it's his job, until he's ready to come back to work, there's not much that can be done. But once he's ready to come back to work, if he loses his job, let's talk about the severance that he's going to be owed. So I can tell you how much severance, of course, I'm an employment lawyer, but I want to show you how you can find out yourself how much severance this person is owed or how much severance you're owed if you ever lose your job. So let us turn our attention to pocketemploymentlawyer.ca. Again, pocketemploymentlawyer.ca. We'll use our severance calculator feature, and you're going to be able to see on the screen exactly how much he's owed. So let's use that now. We know that he's been there for 9 years. We know that he's not being offered any severance. You see all his stats on the screen, and you can see that the result is he's owed right around 14 months of severance. 1-4. That's a lot of compensation. That's a lot of severance. That's how easy it is for him, for you as well. If you lost your job, if you're worried about losing your job, if you're curious, if you're simply wanting to educate yourself about your entitlements. When it comes to severance, you go to pocketemploymentlawyer.ca, use the severance calculator feature. You may be surprised by that number. But that number is correct. It's what the law provides for you. So it's important that you're always armed with that information.
With the doctor's blessing, he goes back to work. We'll say that scenario. Does he have to go back to the exact same job from which he left when he went off on medical leave?
Yeah, the employer is going to have a small amount of leeway to change his job. So the expectation would be when he's cleared to go back to work, that he goes back to the same job, same pay, same hours of work that he had before. If his employer changes that in a significant way, that's going to be what we call a constructive dismissal. Constructive dismissal happens when the terms of your employment get changed. We'll talk about that more later today in the show. So yes, if you're off on a medical leave, whether it's for a week, a month, a year, or longer, when you're ready to come back to work, you should be going back to the same job you had before. If not, again, constructive dismissal.
You have any other questions? It's simple. Go to terminationquestions.com. Yet another website for you to use. Absolutely free and anonymous. Terminationquestions.com. We'll get to the first one for today, Lior. This one from Irene. She says, my neighbor who runs a successful small business says that most of the rules you talk about on your show don't apply to him, only to large employers. Is he right?
I get that asked very often. It's a legitimate question. It's not a question that I'm going to mock at all. There's a lot of misconceptions, especially when it comes to severance, that severance somehow only applies to large employers. Let's be very clear. When it comes to termination and severance, when it comes to really anything that we talk about on the show, it applies to big companies, it applies to small companies. Whether you're working for a company with 10,000 employees or one employee, everything we talk about applies to you. Certainly when it comes to severance. I know there's a misconception that severance only for a large company. Not at all. Your full entitlements, what we call your common law termination entitlements, are going to be the same big company or small company. That's why it's important to get advice from the right sources, like this show. And again, as I said, if you're not sure how much you're owed, pocketemploymentlawyer.ca.
And along those lines, as we go to a break, things not to do until you talk to an employment lawyer. That is coming up. Helpful tips, you could call them. But first, we'll get to a short break. Phone call, in the meantime, anytime, to Lior's crew, 1-855-821-5900, help@employmentlawyer.ca. We'll continue. This is the Employment Law Show. Stick around. People think you should go to the government to get severance pay. EmploymentLawyer.ca says that is a myth. Government can only help you get minimum severance, but not everything you're entitled to. Always check with the employment lawyer first at EmploymentLawyer.ca. If your long-term disability claim is denied, should you appeal?
Appeals often fail because insurance companies control the process. So long as you appeal, you're playing by their rules.
You should never appeal the denial of your disability benefits. Appeals are just a mirage of false hope.
Don't. That's their process. Take it out of their hands and fight for your rights with our help.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think their employer can make changes to their job. EmploymentLawyer.ca says that is a myth. Your employer can't change your pay, hours, or duties. You may be entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. All right, welcome back. Employment Law Show. John Scholes, Lior Samfiru. By the way, the most positively reviewed employment law firm in the land, Samfiru, Tumarkin, LLP. To reach out, 1-855-821-5900. The show is all about education. That's what we do for every half hour that we're here. And we'll continue to do that today, Lior. The topic is things employees should never do before talking to you or another employment lawyer first. Some of these seem obvious, but you know that's why we do them, because they're not obvious. They keep coming up over the last 10 years over the radio show and otherwise. First one is this: an employee should never accept or sign back a severance offer without talking to you first.
We'll get the big one out of the way, I guess, first. So that is the biggest one. It's probably the number one thing you should not be doing ever without seeking legal advice, and that is signing off on that severance offer. Once you sign off on it, there's no going back. There's no changing your mind. There's no realizing that you made a mistake. Now, why is that important to know? It's important to know because the vast majority of cases, I'm talking over 90% of the time, when you're let go, when someone's let go, what they're offered is pennies on the dollars. It's a small fraction of what they're actually owed. But you may not know that. So you go ahead and sign it. Yeah, I guess it sounded okay, so I signed it. When you realize a week later that you were owed an extra $75,000, you're not going to be able to do anything about it. Now, I know that there's a deadline. I know there's a deadline in that severance offer. They want you to sign by Friday at 5 o'clock, and you're going to feel that pressure. Well, I'm telling you right now, ignore that deadline. That deadline is meaningless. Your rights don't expire on Friday or Tuesday. In fact, you have 2 years to pursue those rights. I got an email the other day from someone who realized that the package that they accepted was $110,000 less than what they're owed. And they wanted me to help them. They felt that they signed under duress. Unfortunately, I cannot. $110,000. Don't let that happen to you. You may not be owed $110,000 more. You may only be owed $10,000 more. But that's still money that you're legally owed. So when you're staring at that severance letter, give us a call. Do not sign no matter what without speaking to us. You can go to pocketemploymentlawyer.ca to use the severance calculator feature there. Easiest way to do that, 24/7, free and anonymous. But please, do the right thing. Don't sign and then get legal advice.
Point number 2, another thing you should never do without talking to an employment lawyer first, should never accept a significant unwanted change to their job. It could be location, change of shift, change of hours, change of pay. There's an endless list, right?
So an employer does not have a right to make unilateral changes to terms of employment, significant changes. So reduce your pay significantly, change your hours, demote you, etc. The problem with accepting that is that you've given the company the right to do it again. And what happens with that is this. Once the company is given that right to do it again, when they do it the second and third time, you won't be able to do anything about it. So you may have taken a 15% pay cut now and you think, okay, that's going to be the end of it. Unfortunately, because you let that 15% pay cut happen, you accepted it, continued working, the next time they reduce you by 15 or 30 or 50%, you won't be able to do anything about it. So when it comes to changes to the terms of employment, we have to think about this concept of constructive dismissal. It may allow us to treat employment as being terminated and get severance. So whenever you're dealing with a change, let's talk. Before you accept, before you just continue working, let's talk about whether it is a constructive dismissal and what you stand to gain or lose by accepting or by rejecting.
Does an employer have a little bit of wiggle room when it comes to these things? I mean, if you got someone who's working 9 to 5, if the employer says, okay, now you're working, 10 till 6 or 9:30 to 4:30 or whatever. And same with the pay or with a location, if it's just down the street from where they are now, they have some leeway?
So an employer does have a small amount of leeway to make changes to terms of employment. So for example, if your hours change from 9 to 5 to 8:30 to 4:30, that's not a significant enough change. The employer will be able to do that. But instead of 9 to 5, you're going to be working 12 to 8. Well, wait a second. That's a massive change. Can't do that. So, same with pay decreases. Really anything below 12, 15%, an employer may be able to kind of squeak by. Anything over that, not possible. So yeah, the devil is in the detail. If you're not sure if the change that you're facing rises to the level of constructive dismissal, well, that's why we're here. Give us a call. Let's chat about it.
Well, you said devil's in the details, man. That point number 3 nails that one home for sure. Another thing you should never do before talking to an employment lawyer, sign back an employment contract without understanding exactly what's in that thing.
Well, many people might say, well, why shouldn't I? Check the salary. I know how to read that. Its salary was fine. I wanted 4 weeks vacation very badly. They gave me that 4 weeks vacation. I also wanted a 10% bonus. They gave that to me. Why am I not signing immediately? Well, you're not signing immediately because there may well be and likely are other terms that are even more important or problematic. For example, there could be terms that limit your severance. That could cost you tens of thousands of dollars. There could be terms that allow the company to change your compensation, hours of work, responsibilities. So you think you've accepted a job paying you $80,000, but what happens if that salary can be reduced to $30,000 because that's what the employment agreement says? What about a non-solicitation, non-competition? So there's a lot of terms that are very problematic. You are better off as an employee not to have an employment agreement, to start a job on a handshake, something on the back of a napkin. But if you are going to be presented with an employment agreement, before you sign, let's talk. Let's understand what you're signing. Oftentimes you can negotiate or eliminate the bad quote-unquote terms, but you have to make that call.
Yeah, naturally you're thinking, no, Lior, I feel safer with a 30-page document. I feel secure.
Yeah, I mean, and I always say that you want stuff in writing, and that's very true when it comes to pretty much everything in employment law. But when it comes to an employment agreement or a job offer letter, less is more. Again, not having one is better than having one, and having a 1-page document is a lot better than having a 10-page document. So, but if you are presented with that full document, then a lot of times you will be. we need to have it reviewed before you just go off and sign it.
Again, we're talking about things you should never do as an employee before you talk to an employment lawyer. Point number 4, an employee should never stay silent when they get a bad performance review.
So oftentimes a performance review, a bad performance review, is a step towards being terminated for cause. An employer is often building a case to try to terminate employment for cause. So what does that mean? You've got a bad performance review. If you don't say anything, you're deemed to have accepted it. And then later on, when maybe something else goes wrong, the company can say, well, you know, we already had you on a bad performance review, which you've accepted. Now we can terminate you for cause. And it's that silence that hurts you. Remember, silence is the same as acceptance. If you get a bad performance review or you put on a performance improvement plan that you don't agree with, you have to say something about it. Now, I say, but really what I mean is write. You have to put it in writing. Send an email, send a text message if you want, outlining why you disagree with it, assuming you do. If you do agree, that's okay. But if you disagree, if it's not accurate, if there's something that the employer is missing or hasn't taken into consideration, say so, and say so in writing. You can be very respectful about it, you can be very professional about it, but you have to say so. And by doing that, what it means, it's going to be that much more difficult for the company to rely on it if it ever wants to terminate you for cause. So don't be silent ever. If you get a negative performance review, let's have a chat about it. Let's talk about how to respond and whether you should be concerned, but don't just accept without speaking to me.
Reaching out, by the way, before we get to our last point for this segment is 1-855-821-5900, help@employmentlawyer.ca. Okay, one more to go. Another and last thing you should never do before talking to Lior and his team is you should not rely solely on the advice of your neighbor, family member, Steve, or Google Law School for any advice when it comes to employment law, ever.
So about 10 years ago, I was frustrated when I saw so many people, especially online, getting advice from people that I didn't even know or people that they felt knew the answer but didn't. And because of that, people were getting the wrong advice, losing out, walking away from entitlements. That's why you and I 10 years ago started doing our radio show, now our TV show, to educate the public. So when it comes to employment law, I know it should go without saying, but I see this all the time. Get advice from the right sources. If you're getting advice from someone when it comes to employment law that's not an employment lawyer, then you're not getting the right advice. It's as simple as that. Don't go online on message board and ask your friends there that are all interested in golf what the answer is. They don't know. They can't advise you. Don't go to the real estate lawyer that you used to when you bought your last house to give you employment law advice. They don't know. If you don't like me, that's okay. Speak to another employment lawyer. But when it comes to things that are as important as your job, as your employment law rights, you have to seek advice from an employment lawyer.
1-855-821-5900 again to reach out anytime. Let's get to one more phone call from our radio show before we take a break. Again, employmentlawyer.ca to find a radio station in your community where you can tune in.
I've been working for this company for a long period of time. Been off for just under 2 years on a long-term disability matter. And I got notification earlier this year that my claim was being terminated. So I reached out to the employer and I explained to them what was happening. They basically just wiped their hands with it and said, well, that's not us, it's the insurance company you got to deal with. Just trying to figure out if the employer has any obligation to the employee.
It's a great question, and I see this very often. And you and I talk about this. You talk about this also on the disability law show, that people get cut off oftentimes after 2 years of being on disability. Yep. But his employer here is correct. That is a matter between him and the insurance company. The employer doesn't have the ability to force the insurance company to keep him off or to keep him on disability benefits. That's the bad news. But the good news is, it's not that difficult to deal with the insurance company. We have a whole department at our firm just exclusively devoted to that, to dealing with the insurance company to keep people on disability benefits or to get them compensation if they're cut off. So if you find yourself being cut off or denied disability benefits, the insurance company is not cooperating, they don't believe you, they don't believe your doctor, let's have a chat about that. I'll connect you with some of my colleagues dealing exclusively with that. Yes, that can be resolved, but it is a matter between the employee and the insurance company.
And with that, we'll take one more small break before we get to our last few minutes. In the meantime, 1-855-821-5900, employmentlawyer.ca, and help@employmentlawyer.ca. To reach out through email as well. And we'll continue. Employment Law Show. Stick around. People think contractors aren't owed severance. EmploymentLawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you, they may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. EmploymentLawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at EmploymentLawyer.ca. And welcome back. A few minutes to go. Let's get right to it. EmploymentLawyer.ca, the website, the media tab. Find a radio show in your community where you can catch our radio show that's been happening for over a decade. So we'll tune into that when you can. We'll get one more phone call from that radio show now, Lior, and talk about it.
We were given written notice in December that our job would end the end of May. At the end of May, it'll be 13 years. I'm 75. At first, because we were given written notice, we understood that they weren't going to pay any severance. Of course, we have stayed on because there was rumor that we might get something. I just want to know what we're entitled to. Clerical.
So we talk often, John, and a lot on the show about severance. Yep. So severance really refers to the amount of compensation that a company has to pay you if they let you go. But there's a way a company does not necessarily have to pay you that severance, and that is if they give you the equivalent amount of notice. So for example, someone that is owed 6 months of severance. If instead of that they get 6 months advance notice of the termination of their employment, in that situation the company would have met its legal obligations and does not have to pay them any severance. Now, if the company does not give sufficient notice, then they have to make up the difference by way of severance. So let's talk about this person here. So we know that this person, after 13 years at the age of 75 and in a clerical role, they received 6 months notice of the termination of their employment. Now, if 6 months was enough, then they wouldn't be owed anything else. Well, let's find out if it is enough. Let's go to pocketemploymentlawyer.ca and let's input our information here into our severance calculator. So as you can see, this person is 75, 13 years of age, and in the clerical role, and was offered 6 months, or was given 6 months notice. Well, you see at the bottom that what they really should have gotten is 16 months, 1-6. So what does that mean? That means that at the end of the 6 months, the company has to make up that difference. So an additional 10 months of severance. 6 months notice plus 10 months of severance. Together, that's the 16 months that the person is owed. Now, what is important to remember here is this. If you've received advance notice of termination, yes, you may be owed severance at the end of it. But if you resign before then you're not going to be owed any severance. I had a case very recently, John, where someone received 4 weeks notice of termination and they resigned with 2 weeks to go. They would have gotten another 9 months pay at the end of it, but they didn't because they didn't stay till the end. So if you are going to lose your job and you do get notice, you want to work till the end. I mean, obviously, if you have other reasons to leave, maybe you found your dream job, sure. But understand that if you leave before that last day, you're not going to be owed any severance. As I said, you want to find out how much severance you're owed, pocketemploymentlawyer.ca.
And this particular caller, 75 years old, that really increased that number up to 16 because age is a factor.
Age is a factor, and the law assumes, right or wrong, that it's going to be harder to find a job at 75 than it is in 35. So you're going to get more severance. That's why 16 months pay, and for her it's another 10 months at the end of that 6 month notice.
And we are done. Hope you learned a lot. Want to reach out? Here's the option, 1-855-821-5900. The phone number, email is help@employmentlawyer.ca, and the website, pocketemploymentlawyer.ca. Free and anonymous, and use that first. We'll catch you next time on the Employment Law Show.